So on Monday, we dealt with the question 1, 2, and 3 of November 2021. Now we are going to look at question 4, 5, and 6. Yeah, so we are going sequentially. So on the website there is June 2008 to 2019 question and answer, then June 2021 question and answer, going for 600. Then we are at November 2021. We are going to go all the way to November 2024 papers. Then we are going to revert to part B of year 2008 to 2019 in the Q&A to continue with the drafting. So legal writing and drafting is a very practical subject. This is not a subject I will encourage you to just attend class. This is a class I will encourage you draft your drafting documents and send so that we can display them, because drafting is a very practical subject. Writing something practically is one thing and saying is another thing. So when you are doing something practically, you know where you are going wrong, because drafting is a skill. Knowing how to put the content and the structure, even the timing. So Akiaga, when next classes, I want to see your drafted documents.
I want to really try. You know what I did not know would happen is that pupillage would be this taxing.
Of
Because
course.
that office is very busy. I enter there at around 7 and
Yes.
I leave at 6.
Mm-hmm.
And it is work and work and work and work. But I want to do my level best so that next Friday you will see my draftings before. I'll even spend the entire
you
night
can do
doing
this,
them. Yes.
For example, next week we are dealing with April 2022 papers,
Or April 2022. Okay. Not 2021.
April 2022.
Because this is November.
Because it's November 2021. The next paper is April 2022. Professional ethics and legal writing and drafting. So you can draft during the weekend and send me,
I think I should do that. I'll do it tomorrow so that by Sunday you'll have them. April 2022. Okay.
Yes.
Okay. You'll have them. Okay. Thank you. Okay.
So you can see the paper on your screen.
No, I can't see it.
Okay, let me share. And thank you for sharing a clean copy.
Welcome.
You can see now.
Yes, it is now visible.
Yeah. So we are going question 4, and I'm going to read. You are senior legislative drafting working for the Senate in the National Assembly. You are senior drafter working for the Senate in the National Assembly. That is a mistake. Senate and National Assembly are parliament. So you cannot work in the cannot work in the Senate in the National Assembly. So that was a typing error. So it was supposed to be you are senior legislative drafter working for the Senate in Parliament. During induction, and that is good qualities of a lawyer. You detect the typos when you are reading. Yeah. During the induction of the newly elected and appointed members of Senate, you have been appointed to address them on matters to do with drafting of bills, subsidiary legislation, and other legislative proposals. However, for those legislative proposals to be proposed, the legislative drafter requires instruction from the proposer prepare actions and outlining the contents of instruction that will enable you to prepare for legislative proposal. What do you think this question is testing, Wakiaga?
Well, when I was studying it, I grouped my findings into three.
Yes.
First, the first part of it was what goes into the legislative proposal.
Yes.
The content of the legislative proposal.
Yes.
And then I also looked at the structure, how you structure the content.
Yes.
And then lastly, I was looking at the drafter himself.
Yes.
Yes, that is how I viewed it.
Okay.
Yes.
Yeah. Yeah, that is very correct. And Nicole did the question practically. So we are going to look at her answer. Before we look at the answer, this question is testing your knowledge on instruction notes that a legislative drafter is given. Yeah, so you are a legislative drafter. Another person is going to give you the proposer of a given bill or subsidiary legislation, usually instruction notes. If, for example, a member of parliament wants to draft a bill, so you tell your legislative drafter working maybe in the Attorney General office, these are the notes. So the question is testing you on drafting, the context of such instructions, and the instructions here are very general in nature, because these members of parliament want to be taught how to draft bills and subsidiary legislation and other legislative proposal, notice of motions maybe. So it is not specific to your bill. So yeah. So if you look at the document that I'm sharing there, this is a drafting of the drafting of instructions note. So I hope you can see it.
Yes, we can see it.
Yes, we can.
So this is a KSL document, Kenya School of Law document by Madam Kongo. Yeah. So content. What are the content of drafting instructions? Yeah. Number one, so should the instruction should contain sufficient background information to enable the drafter understand the problem or initiative. Yeah. This should include framework, current legislative framework, and it's intended to deal with. The principal objective of registration should be clear and concise. Yeah. So instruction should be straightforward. Instruction should include important issues of policy and administrative drafters, e.g. power to make regulation. If drafting legislation should be subject to the instruction should describe the nature of project timelines. It will also include information about the availability of relevant court decision or indication of availability of legislation in other jurisdiction. Instruction should mention any acts of regulation to be repealed, any transitional provision needed to be dealt with issues arising as a result of repeal of one law, enactment of the law. should set a proposed time frame for coming to the force of part of the registration or information about how it come to force. Whether other departments agencies are to be affected. Whether there have been consultation of any outstanding issues. Yeah. So, what form should drafting instruction take? Most legislative drafters prefer to receive instruction in a straightforward narrative form. They don't object to instruction in form of draft, preferably annotated with explanation. The departmental drafts are made up of instruction only, and legislative drafter will prepare their own draft based on the instruction. It is wise to involve the legislative council early enough to put their effort. So, now this is drafting of his drafting instructions. But this question is not specific to any particular bill, no any particular subsidiary registration to be given those things like the background history, yeah, all those things that I've read. So this what your lecture notes are telling the Court of Instruction will enable you to prepare the legislative proposal should be very general on the drafting of bills, subsidiary registration, and another legislative proposal, because this is you are going to it is going to be presented to newly elected members of parliament. So this thing legislative this drafting instruction should be very general in nature. So what should it include? Yeah. So what did it include? So you are going first of all to discuss. That person is going to ask you to discuss the legislative process, because these people have been elected as members of Senate. So they want to know how bills are drafted. So I'm going to so part of your answer should have included how a bill is done. So the legislative process. The legislative process. So I'm going to share the document. This is the legislative process document. I know you have it from Parliament website. So this proposal is going to tell you, as a drafter, you are going to discuss to the members of Parliament what? Number one, what is a bill? So you are going to, because remember, these are newly elected senators. What is a bill? A bill is a proposal or introduction in the House of Parliament. You discuss what a bill is, originations of a bill. And here you have interest on individual members because they can introduce. Yeah. Introduction of bill, publication scrutiny. A member wishing to introduce the bill needs to be first to present to the Speaker of the legislative proposal within studying. Yeah. That is what publication of the bill. Publication of bill go to the government printer. Then, before approving publication of legislative proposal, the Speaker takes account of the recommendation of relevant committee. Publication of the bill, period of the bill, the publication. Remember, you are going to take them through how they are going to bring up the bill. First reading, stages of a bill. First reading. What is the first reading? The proposer is going to tell you to include in your notes what is first reading. You are going to tell them what first reading of the bill is, what is second reading, what is committee stage, what is reporting stage, what is the third reading. Yeah. Rows that require consideration by both houses. Remember under Article 104, there are these bills that must go to concurrent by both houses. You need also to inform them that. Yes, yeah. Committed to bills to mediation committee. Remember, if there is no agreement between the Senate and the National Assembly, the bills that need to go to the National Assembly, especially that those that are touching on national issues, you go to mediation. You need to tell them what is mediation. Yeah, appointment of mediation team and all those things. Then, yeah, legislative process, that reading, then the presidential assent. So you discuss all those things. So these are the notes. Remember, is the proposer telling you as the legislative drafter what are the things that you are going to draft to present to them. Then on subsidiary registration, you discuss there's a document I want to display. Yeah, what is a subsidiary registration? Remember, this knowledge you can use this in another question. So you all this document I'm talking about. You need to read them for your legal writing and drafting class. You are going to use them. So, yeah, it's called. I thought I had saved it. Let it open. So it's called process. It's called what? Processing of statutory instrument. Hope it is visible on your screen. Yeah. How statutory subsidiary registration is generally these are regulations in context of parliament. So these members of parliament need to know how they are processed. Yeah. And remember, the regulations you usually come from the executive. And the powers are given. It's the Parent Act that gives the minister power to make regulations. And they need to be conformity with the Statutory Instrument Act. Then they are tabled to the Committee of Delegated Registration. So the committee must report to the House within 28 days after scrutinizing the regulations. Yeah. So that is how you are supposed to answer that question. This question is not was not the drafting instruction was not directed to any kind of particular bill. It was not any kind of particular bill. It was general in nature. Yeah, in context of Senate, what I have just shared in brief. So if we look at Nicole answer, yeah. So question 4. A legislative can be referred to a bill. Effective draft requires instructor to issue with him with the legislative instruction, draft instruction. Below are content that must be captured in legislative instruction. Proposed registration. The registration instructor must provide the drafter with the name of the proposed legislation. For example, the Nuclear Atomic Commission bill. This will enable the drafter ascertain the branch role in which it is to draft. Sponsoring department. There would be need to indicate which department will be in charge of providing funds for legislative proposal. This capture the name of the department. The contact details of the department should be effectively captured, being the name of the person in charge of the department, address, telephone number, date of cabinet approval. This would effectively capture the date which cabinet approved the proposed legislation have been tabled in them. Background information. This would capture what is necessitated need to draft the proposed legislation. If there is a gap, it helps to clear what extent is doing so. Main objective. Give a background of the main objective, what the proposal helps to achieve. This way, the drafter will be able to ascertain the gaps legislation had. How the objective will be achieved. Give guidance on how the set objective will be achieved. This should be reasonable and workable. Power to make regulation. Indicate which parties or body will make the made of coming up with the regulation and practical implication of the process, consultative opinion, relevant, act of parliament, commencement, outright. So this question is not, the answer is not correct because remember, the question is asked, it's very specific on prepare election notes and the content is that to enable you to prepare the legislative proposal. So what is the legislative proposal here? It is very direct. That during induction, the newly appointed member, you have been appointed to address them the matter to do with drafting of bills, subsidiary legislation, and other legislative proposals. So the note should be on drafting of bills, subsidiary legislation, and other legislative proposals, which is called notice of motion. So these are the contents which you needed to discuss. But if the question was general on what is contained in drafting instruction to a drafter, general, what is contained without specific, you could have said all those things. But here, It was directed on drafting of bill, subsidiary legislation, and the legislative proposal. Yeah, you can also be told that the legislative proposal is a nuclear bill, for example. So you need now to be very specific on have knowledge on what may be contained in the nuclear bill. Are we together?
Yes, we are together.
We are together, Nico.
I'm a little bit lost. So the question
Yes,
wasn't like specifically for drafting instructions. So I did it wrongly.
you did it wrongly because the drafting
Mm-hmm.
instruction was directed to drafting of bills,
Mm-hmm.
subsidiary legislation and legislative proposal. So what is contained in when someone wants to draft a bill or subsidiary legislation or other legislative proposal, notice or motion, what content? Remember, the proposal giving you this draft instruction so that you can prepare note, you can prepare like notes to go and present to the new members of parliament. Unaona? So you discuss what is a bill. How does a bill comes into force? A member originates a bills. The first reading, second reading, third reading, fourth committee stage, mediation, presidential referral or assent. Then statutory legislation, what are they? Are they brought to parliament? Which committee? What time does it take? Unaona? You can also discuss
Yeah.
about legislative proposals. Other legislative proposals are also notice of motions. You remember everything is brought as a notice of motion in parliament. How does a member bring a notice of motion? So yeah, but if the question was on what is the content of a drafting instruction to a legislative drafter, in general, this was could have been the your answer. Unaona?
Yeah.
Yeah. So I hope that is clear. So we go to the
Yes,
next
it is.
question. So this question related to this question is question 2B, November 2015. So like this, you could have answers. Question 2B, November 2015, on features of a comprehensive drafting instruction. General question. It was asked that way. So that is was the answer for this you have given. But this was very specific. We are going to deal with other question on drafting instructions when we revert back to the year 2009, 2008 to 2019 part B. It has several questions. So you are going to perfect your answers on that. So we go to the next question. Maria O. Salad Lady, question 5, November 2021. Maria O. Salad Lady, area rent amounting to 10,000. The tenancy agreement provides that the rent shall be paid by the first of every month or else the penalty charge of 500 applies. However, by 5th January, when Aria visits your chambers, the entire rent amount is in arrears. Assuming that you are an advocate of High Court of Kenya, draft the demand letter in plain English. So, this is a question of drafting of a demand letter. It is one of the easiest question you can be asked. And yeah, this is a question someone should get 10 marks. And I want to share a demand letter which I have here before we look at Nicole's question, drafting. So, yeah, this is a demand letter. So, number one, and this is how the marks are usually awarded. If it is 10 marks, I hope you can see the sample demand letter on your screen.
Yes, we can see it.
So number one is the address of the person sending the demand letter. So here you are the advocate. So you are going to put your firm, where it is located, PO box number, email. That is one mark. So your reference, our reference, and the date, all this is another mark. So that is 2 marks. So here you can say by recorded, by email, or by delivery, physical delivery. That's another mark. Then the addressee, the person which is addressed to. Those are 4 marks. You give as many details as possible. Then your ref. What is the title of your demand letter? This letter was on defamatory statement by you. So that is another mark, 5 marks. Then this is how you open your demand letter. We act for our client. So that is another mark. Whose instructions we address you here under. So that is a mark. So those are like 1, 2, 3, 4, 5, 6 marks. So now you got to the 7th mark, you give the history, the facts. What happened on 18th February? You wrote a published the first selling book, this, as a result of the words published detrimental. This is a defamation demand letter. What happened? Destroying his standing in the society. So this is the background. What happened? Why are you issuing the demand letter? So you give the facts, the history. So that is another mark. Those are like 1, 2, 3, 4, 5, 6, 7 marks. Then you go to instruction. Our instruction, therefore, is to demand, which we hereby do. Hereby do is very, very important. Admission, what are you demanding? Admission reliability, so that we can tax quotum to our client. And we do what? We do immediately stop further defamation. Yeah. Then, if he does not do that, take notice. This is the 9th mark. Take notice that we should not receive response from you in the next 29 days. You are going to institute your suit. Then you sign. 10th mark. So that's how this thing is marked. So if you go to Nicole drafting, so which is displaying on your screen. So KK Advocates, first from Pangano to us, PO box, telephone, email. That is correct.
It's not showing.
That is correct. Yeah.
You are not sharing it.
Let me share. So yeah, now it is sharing. Sindio?
Yes, yes.
So yeah. So advocates, our ref, your ref, date, that is correct. Those are 2 marks. So who is the person? Maria. Maria is the person who was the money. So you, Maria FK Towers, PO Box. Dear Madam. So reference default in payment of agreed rent. Good. We refer to a verse subject on which you have been instructed by Aria, our client. Very good. To address you as follows. You are our client. You and your client entered you, so you give the history. Tenancy agreement upon application of one of the apartment. In the said apartment, the house rent was clearly captured as Kenya shilling 10,000. Payable on before 1st every month. Late payment would accrue a penalty of 5,000. Yeah. Our client made us aware of defaulted and rented despite repeated attempts to correct the said amount of Kenya shillings. 10,000 to the amount 500, but you have not come forward with the money. Our instruction are to demand for you immediate settlement of 10,500. Good. Good. Yeah. Then take notice that unless you comply with the next 7 days from the date of this, we shall commence proceedings against you. Yeah. You can also take that you can distress of rent. Yeah. Yours faithfully, KK Advocates, Kemboi Kiprangat, copied, and you use 20 marks. Yeah. So this is a question that you did very well, and also you are within the given marks, given time. So this one I will award you 10 out of 10.
Question,
so you have, yes.
There's something you talked about, but okay, in some demand letters I don't see it, some I see it. The mode of delivery. How critical is it? Because when we were discussing it initially, it was 1 mark.
Yes.
Yeah, so and it is missing here.
Yeah, you can put it here. You can put here by after by recorded delivery. I don't think this is very, very important.
Okay, so we can omit it.
You can omit it. This is not very, very, very important.
But it is safe to include it because
yes.
In case it doesn't earn any mark, still you lose nothing.
Yes, you can.
But if
you
it earns, yes, I suggest that when we are drafting, we include it.
Yes, you can say by email and by physical delivery. You know, advocate send by email, then physical delivery. So you put here after your reference, after your reference, after your reference, Nico, you put here by email and by physical delivery. Sawa?
Yes, because I've seen in court, there's a time we were in court, and the client, no, the person who was supposed to have been served was denying being served. And yet the emails which are there are the same emails which are in their website, and they were actually denying being served. So I think that part is very critical. How did you serve? Because I remember the judge asking, the magistrate asking, how did you serve them?
Yes.
Yes.
So we are together, Nico.
Yes, we are, but I have 2 questions.
Yes.
The first one is, when do we use the term without prejudice in your letter? Like, how can we tell we're supposed to include it or we're supposed to omit it? And then, should I go to the second one or should I let you respond to the first one?
So you can, I usually give student the interact. So Stanley Wakiaga, you can try to answer that one.
Yeah, without prejudice is usually used when you are the letter you've written, you do not intend to rely, you do not intend that the person you are serving to use it as an evidence in court.
Yes.
Yes. So you put without prejudice, because you can write something, then the other party uses it as evidence, and you do not intend that that particular document be used as an evidence in court.
Yes. And you see now, a demand letter is not a without prejudice document. Usually the without prejudice document is used when you are trying to negotiate with the other party. Unaona? So you can try to negotiate and you admit some liability, but you are saying without prejudice that this, in case these negotiations fails, it cannot be used in against you in court. The other question?
Okay, thank you for that. Then the second question is, you see, when you're drafting, okay, like now the sample of my letter, I've written Dear Madam. When I'm signing, okay, it's maybe Dear Madam stroke Sir. When I'm signing off at the end, should I use yours? Okay, basically, I want to believe it's yours faithfully. But if I'd used Dear Maria, how would I have signed off? Using yours faithfully still, or it would have changed to sincerely now?
Wakiaga, you can try to answer that one.
Well, I do not have a specific answer for it, but I think for conventional purposes, faithfully is more ideal. But I really do not know at what point you use sincerely and at what point you use faithfully. And I've also seen some other people use yours truly.
Yeah. So my answer to that will be sincere is usually used in non-legal context. Unaona vitu kama love letter, unaona? Yeah, love letter use you are sincere, but when it is official like this demand letter, you usually use yours faithfully. So here putting your dear madam or dear Maria, dear madam or dear this lady is called Maria. Yeah, it does not change anything here. It just end by yours faithful because it's official. Yeah.
Oh, okay. Because I want to believe we were taught differently in KSL, but I am guided now.
Yes. So you just be putting yours faithfully. Yeah.
Okay.
Yeah.
And I also remember our teacher, Mr. Kuloba, insisting that yours faithfully is the most conventional one.
Yes.
Yes, I remember that.
It's the most conventional one. Yours sincerely is usually, my understanding is usually used in non-legal context.
Yes.
So we go to the next question of the day, the last question of the day. Yeah. So we before I move out from the question 5. So I said that demand letter is one of the most easiest question you can do. You can be also asked to draft a client care letter, which you use the same, you can check. But when you have an opportunity to draft, these are questions that have been tested. You can be used to do an application letter. You can be told to reply to a demand letter. Yeah. So those are some of other questions which have been tested on this area. And if you have an opportunity, we are going to look at them. So letters generally is not a hard area to do. When you're told to do a letter, I think this is a question you can get full marks, 10 out of 10. Yeah. So we got to the last question of the day, which is question 6. Draft the legislative proposal that to amend the following provisions accordance with the stated instructions. So, question 6 generally is asking you on amendment of legislation. This is one of the difficult areas to student. So, amendment to registration. Good. So I'm going to talk about it kidogo for your knowledge before we go to the substantive question. Yeah. So I'm going to display a document here.
And Mwalimu, as you display the document, I've really been trying to understand this and I've literally failed to understand it. It came in the exams na nikaanguka nayo one lege. So I'm very keen. I want your guidance here because I have no idea at all
Yes.
how to amend the legislation.
Yes. So I want to give you a guidance on this is, as you know, I have admitted is one of the most difficult. I know the question that student fail. For example, question 4 was very difficult and question now 6. The chances of question 4 coming again in an exams is highly unlikely. Remember, the last question on drafting instruction was asked in 2015. Now it came again in 2021. But amendment of registration may come in. You can come in every exams. So it is a very critical question. So on your screen, I'm displaying the competition amendment bill. Yeah, so let me share. So how do you amend a registration? You amend a registration in 3 ways. Note, by deleting and inserting. So you can delete a section and insert another section. You can delete a subsection and delete and insert a new subsection. You can delete a paragraph and insert a new paragraph. So I hope you know the difference between an article and a section, a subsection, and a paragraph. You know the difference.
Yes, I think I
Yes.
know the difference.
You know, Nico, the difference?
Yes.
Okay, very good. So you can be, that is the first way. Of course, an article is the constitution, when you are told to amend the constitution. But if it is an act of parliament, you use the word section, subsection, and paragraphs, depending on where you have been told. Number 2, so you can amend the second way you amend a registration is by deleting completely. So you delete completely an article, a subsection, a section, a subsection, a paragraph. So unaiondoa kabisa, depending on the instructions.
Mwalimu, a question
Yes.
kindly.
Yes.
Okay, for maybe if it's an article or a clause in the Constitution, I want to believe we normally use the term repeal. Does that also
Yes.
apply for a section, like we repeal, and then for the subsection is where we now delete? Or are the terms the same? Delete, repeal, the same?
It is the same. I want to that's a very good question. I want to you know that our Kenyan constitution has never been amended. You know that.
Yeah, but we amended one in the exams and it almost killed us. I saw the question though in a paper. I think the previous papers you had mentioned the exact question, but I don't think there was an analysis of the question.
Okay. So I want to display to you the constitutional amendment bill. Yeah. I want to go very slowly on this. So I want to share. Yeah, this is a constitutional amendment bill. Constitution of Kenya Amendment Bill 2024. I want you to look at this and you tell me. So article, just read like this. This is, you can, I hope you can see it.
Yes.
So Article 54 of the Constitution is amended in clause 2 by deleting the words ensure progressive implementation appearing immediately afterwards, the state shall, and substituting, therefore, with the words implement. So it is the same language. Are we together?
Yes.
So Article 97 of the is amended in clause 1 by deleting the words persons with disability. So this is complete deleting. Article 6, Article 107 of the Constitution is amended by inserting expression and see immediately after. Yeah. So we said that you first of all delete by deleting and inserting, deleting completely, and the third way you amend a registration is by inserting. You insert a complete new section, subsection, article. I want to show you an example of where a new subsection was inserted. This is Public Finance Management Bill, Public Finance Management Amendment Bill of 2024. Yeah. So, yeah, if you look at number 2, the Public Finance Amendment Act hereby is referred to the principle. It's amended in section by deleting 3 months appearing in subsection 1 and substituting thereof. With the words 1 month. The Principal Act is amended in section 24 by deleting the words 3 months appearing in paragraph B and substituting thereof. So the word is substituting thereof. It's not inserting. Substituting, inserting what I've told you, deleting and substituting. Substituting, deleting and substituting, deleting and substituting. All this is deleting and substituting, deleting and substituting. The Principal Act is amended by deleting section. You can delete a section when it is substituting thereof with a new section. Still. So this is the insertion. This is an example of insertion. So here they did not delete anything. So the Principal Act is amended by inserting the following new section immediately after 195. So after 195 of the main act, usually give it A. So they inserted a new section, insertion of the new section in number 18 of 2012. So 195A, the public sector, so it was inserted. Have you gotten the idea so far?
Yes.
Yes, at some point I got lost, and you said that there are 3 ways of amending a legislation. So how many have you discussed? You've discussed only one or the 3 of them?
I've discussed three of them.
Because at some point my network fell off.
Yeah.
So
the first way is deleting. You delete a word, or section or subsection, and substitute thereof with other one. That is one way. Then deleting completely. You delete. Then number 3 is inserting a new section, subsection, or paragraph. So those are 3 ways.
Okay, yeah, I'm getting.
So we are going to do this. I'm going to do the first question for you. Or you want to try? Let me do first question for you. Let me do first question for you. That, you know, these are 10 marks. They are 10 questions. I'm going to do one for you. Then you are going to do the others. You are going to be trying to do the others. So, Access to Information Act 2016. So, the Access to Information Act of 2016, let me display the paper. We have 1 hour to go. So we have ample time. So the Access to Information Act in fact, I can increase the font. Let me increase the paper font so that it can be seen more well on your side. Anyway, you can be able to read, eh?
Yes, it's readable.
Oh, it's readable, eh?
Yes.
Yeah. Yeah, I've increased. Yeah, I've increased kidogo. You can see that, eh?
Yeah.
Yes.
So I've increased the font kidogo. So the Access to Information Act 2016. So in section 12 of the Access to Information Act, subsection 2, it says as follows: a public entity or private body for which an application for access to information has been may charge a prescribed fee. Provision of the information and fee shall not exceed the actual cost of making the copies for such information, and if applicable, supplying to the applicant. So what are the instructions of this question? Expand the limitation of the prescribed fee that may be chargeable. So this amendment, you're going to do once these people who are going to access this information, they will not be charged anything. So what would your question read? Now, on your right, you are going to. So this is on your right. You are going to write amendment of section 12(2) of Access to Information Act 2016. This is what it will read on your right hand side. And what is the amendment? So it will read this: the Principal Act is amended at section 12(2) by deleting the words in quotes. Has been made, no, may charge a prescribed fee may charge a prescribed fee. So if you are writing, I hope you are writing, you try to read that sentence again. Nicole, can you write?
Yeah.
So it is going to read as follows. I'm going to repeat. The Principal Act is amended at section 12 at subsection 2. This is a subsection of section 12 by deleting the words may charge a prescribed fee for provision of the information, and the fee shall not exceed the actual cost of making copies of such information if applicable. And substituting with the words, and substituting therefore with the word. So if you have we have written a public entity or private body for which an application for access has been made. So if you have directed all this, and now we have to add with this, supplying them to the applicant, what word will you put here? A public entity or private body for which an application for access of information has made shall. So by substituting with thereof with the word shall supply.
Pardon?
Substituting thereof with the word supply shall supply. So I'm going to repeat again, so that the answer inaingia vizuri. So the Principal Act is amended at subsection 2 of section 12 by deleting the following words. May charge a prescribed fee for provision of information, and the fee shall not exceed the actual cost of making the copies of such information, and if applicable. So you write everything that. And so and substituting thereof with the words shall supply. So the words end at applicable, supplying, information applicable, supplying, shall supply, shall supply. So after amendment, it will read a public entity or private body from which an application for access to information has been made shall supply them to the applicant. So you have removed the limitations of prescribed fee. Then on your right, you talked about, you say what? Amendment of section what? Section 12 of Access to Information Act. Another way of writing the amendment, you can write it this way. It will read the same way. So you can start by saying the Principal Act is amended at subsection this of section it, or you can read it in another way. Section 12 of the Principal Act is amended in subsection 2 by deleting the words may charge a prescribed fee for provision of information, and the fee shall not exceed the actual cost of making the copies of such information, and if applicable, supplying. And replacing thereof with the words shall supply. So that is also good. Yeah. Are we together?
Yeah, now I have a question.
Yes.
The word we are adding there, is it provided for, or especially, for example, this shall supply? Where do we get it from? Or we just try to construct a sentence that makes sense?
You try to construct a question that try to make sense. Bora you follow the instruction. Unaona? So expand the limitation of prescribed feed. So this question inataka iondoe hii maneno ya kutoa pesa ndio upatiwe nini hii information. Unaona?
Yes.
So to make it free, so lazima what you are deleting and substituting with iwe continuous sentence. Unaona? So when So when I read what I've done, so it will read a public entity of a private body for which an application for access to information has been made shall supply them to the applicant. You know that is a complete question. So I've directed may charge a prescribed fee for provision of information, and the fee shall not exceed the actual cost of making copies for such information and be capable supplying. Unaona?
Yes, yes, I'm getting it.
Are we together, Nicole?
Yes, we are.
So yeah. So your answer was not correct. You can be told to draft an amendment of a complete continuous act of parliament. So this is how you start. An act of parliament to amend access to information exacted by parliament. This act may be cited access of information shall come into force. So that is how you add. If it is a continuous act, but remember, this question, these are different acts. So, and it is just one mark. So you go directly to what? To your amendment. So having guided you on how to do the questions, now I expect you to try to do the others. So number B, the Banking Act. So section 20A of the financial year. The financial year of every institution shall be period of 12 months ending 31st December in each year. Convert the financial year to be 1st July of the previous year to 30th June of the following year. So, yeah. So this one you can try. Wakiaga?
Well, I think in this particular instance, we are deleting and substituting therefore.
Yes. Very good.
So
read what you write.
Let me just give me 1 minute, then I construct it.
So even you, Nico, you can construct one, eh?
Okay.
Oh, your answer is here.
I missed on some bits of the question, but yeah, it's okay.
You can do it again.
Okay.
So I'm going to give you 2 minutes. You are going to resume 9:50. 2 minutes. 9:50. Try to do again. You can read your answer. Time is over.
So, do we need to read what is written at the edge? That you can say that the Banking Act Section 12A is amended by deleting the words into quotes of 12 months ending on the 31st of December in each year, and substituting it therefore with with the 1st of July, no, from the 1st of July of the previous year to the 31st to the 30th of June of the following year. And then it would read, the financial year of every institution shall be the period from 1st of July of the previous year to the 30th of June of the following year. Would that be correct?
That would be correct. You're doing well. So you don't talk about the act, eh?
Oh, okay.
You talk about the principal act is amended.
Okay, okay.
So when you are deleting the words, so when you say deleting the words, so that the words should be in quotes.
Or we put the words in quotes. The words we are dealing in quotes, and the ones we are in substituting therefore also in quotes.
Yes.
Okay.
Yeah, it is very easy. So you have got a Nico.
Yeah, but I think I had a slightly different answer.
So yeah, sir, you can say it.
The one I've been blocking.
Yeah, say it.
Okay, for me, I went with subsection 1 in section 20A is amended by deleting the words ending on, okay, in brackets, ending on the 31st of December in each year. So like because the bracket, and then and substituting thereof with the words 30th of June, from 30th of June, from 1st July of the previous year to the 30th of June of the following year, so that it will read, the financial year of every institution shall be a period of 12 months from 1st of July of the previous year to the 30th of June of the following year.
So where is the difference between your answer and Wakiaga's answer?
Actually, Nicole's answer, I think, is more convincing because hers include the period of 12 years, 12 months.
12 years, yeah.
12 months. Hers is actually more convincing.
yeah, it's a period of 12 months, eh?
Which I actually left out, and I think it should be there.
Yeah, it should be there. So you are only directing ending of 31st December in each year. Unaona?
Yeah.
So yeah, it is deleting and substituting therefore.
Yeah.
Yes, exactly. Not inserting, eh?
Yeah, is or replacing. You can use the word
replacing, eh?
Replacing therefore or substituting therefore.
And I'm noting that this therefore does not have E at the end.
Which one?
The word therefore, which is used here, I saw it in your document. It does not have E at the end. It is for with OR. It ends at OR.
Therefore, it does not have. Note that it doesn't have. Therefore, it does not have an E at the end. And at your right hand side, you must say amendment of what I displayed. So like now you say amendment of section 20A of Banking Act. Are we together?
Yes, we are together.
On it is also a mark. This one. Let me display maybe. Yeah, let me display. This is very, very important. I expect you the future drafting you do practically. You see this is this one. You can see my cursor. Amendment of section 84 section 84 of, you can say like now the question which you are dealing with, amendment of section 20A of Banking Act. So when you are saying, you say the Principal Act. Can you see on their screen?
Yeah.
Yes. So in other words,
when you are
what?
doing,
Yes.
Yeah. Remember when you are doing the bill, on your right hand side here, you indicate, for example, here is what are you dealing with? Interpretation, or yeah, you remember the main clauses or transition and yeah, transition, savings, no. So ask your question.
What I was asking,
Mm.
where at what point do we use the phrase the Principal Act is amended by? Where do we put that statement?
It is your word. It is here. You see, the Principal Act is amended. That is how you start your nini, your statement.
Oh,
what you say.
That is like how we introduce our answer.
That's how you introduce your answer.
Thank you.
The Principal Act is amended in section 80 by deleting these words and appearing in subsection and substituting thereof with the words. Yeah, that's how you start. That is your introduction.
Now is very clear. What was not clear to me is very clear now. And then at the end,
yes,
and you say you talk of the amendment of like what we've just seen there. Okay.
Yes. So we go to the next question. So your answer, Nicole, was not okay. This one, eh? Now
Yeah.
you are getting. So
I think.
So we got. Yeah, you are getting. So I give you 2 minutes. You do question number 6, the Cancer Prevention and Control Act. So 10 a.m., 10 p.m. You are going to read your answer. 2 minutes. You can read your answer. I've written mine.
Yeah, mine reads, do I introduce it or I just read straight away?
No, you don't ask that question.
Okay.
Introduction is the answer.
Yes. Okay. The Principal Act is amended by deleting the words into bracket kept in such custody as the board may direct and substituting therefore with the words in the custody of the corporation secretary. And now my amended version would be the common seal of the institute shall be in the custody of the corporation secretary and shall not be used except by the order of the board.
You have, can you critique that answer, Nico?
Likely, I think he removed some words that I feel were supposed to be there. Because everything else is okay. But for me, I only deleted the word board. And then now my amended clause.
No, wait. Wakiaga.
Yes.
You did not talk about the section. Is there somewhere you have written that which section is being amended?
Yes, I said, you are right. Okay, let me reframe the introduction. The Principal Act is amended at section 14, paragraph 1 by deleting.
Not paragraph.
Oh, okay. It's subsection.
Yes.
Okay. Section 14, subsection 1, by deleting the words into bracket kept in such custody as the board may direct and substituting therefore with the words in the custody of the corporation secretary.
So it will read what?
And then my answer now would be the common seal of the institute, the common seal of the institute shall be in the custody of the corporation secretary and shall not be used except by the order of the board.
Yeah, that is correct, because remember the question is telling the custody of common seal shall be with the corporation secretary. So it shall be not in the custody of the board. So the main word to be deleted here is what Wakiaga said. You can read your answer, Nicole. That is correct. Let's hear.
Okay, the Principal Act is amended in section 14, subsection 1, by deleting the word board and substituting thereof with the word corporation secretary, so that my final draft would read, the common seal of the institute shall be kept in such custody as the corporation secretary may direct and shall not be used except by the order of the board.
Shall be kept in custody of the corporation. You shall tell me the word that you are substituting with the words. Which words? Okay, you are deleting the word board.
I've only deleted the word board and substituted thereof with the word company secretary, corporation secretary.
Okay, so it is. Let me read what you to read. You tell me if it is correct. The common seal of the institute shall be kept in such custody as the corporation secretary may direct and shall be used except by order of the board. So the custody of the common seal should be with the corporation secretary. The custody of the common seal, the common seal of the shall be kept with the such custody of the. Also is correct, because the question is telling you the custody of the common seal shall be the corporation secretary. The custody of the common seal shall be the corporation secretary. So the common seal of the institute shall be kept in custody of the custody as the corporation secretary may direct and shall be used except with the order of the board. Still is correct. Yeah, it's still correct. So you are getting it. So I want you to do we do now question we do the next on defamation. Yeah, do. When you are ready, you can say your answer. Bakiaga, you can read your answer, eh?
I'm finding it tricky. Let me just give me 1 minute. I construct it again.
Okay. Nicole, you can be reading your answer if you are ready.
The English is not Englishing as well from my end. That is why I actually left it blank the time I was sending it because I really struggled.
Okay. By the way, it's a very easy answer. Let's do this, eh?
Yes.
I
It's
want
extremely tricky.
Yeah. I want you to do this, eh?
Mm-hmm.
With the new knowledge now we have discussed. Let's do start from the Defamation Act, eh? And finish everything, eh?
Yeah,
So Defamation Act is D. So you finish everything, then we are going to start. Next time we are going to start here, eh?
Okay.
Because our time is coming to an end and I don't want us to rush, eh?
Yeah, I think that is okay.
Yeah.
But you've opened my eyes. Hii kitu ilikuja exam and I could only look.
So let me pray for you. Father, we come before you, Lord. We adore you. We respect you, King of Kings, Lord of Lords. We thank you, God, for this class, for enabling us to have this class. The internet, the Zoom, we don't take it for granted, for the knowledge and wisdom. I pray, God, for the participant, Wakiaga and Nicole. Remember them. Give them stamina to do these classes, to prepare well, to participate. We pray for favorable exams in April and a good preparation, favorable question, the marking, favor from examiners, and later when the results are out in May and they have passed their respective subjects, all the glory shall be yours. We pray all this believing in Jesus Christ, our Lord and Savior. Amen.
Amen. Amen.
Yeah.